Number 5, matter of Aponte versus Olatoye. Counsel?
Good morning, and may it please the court. Jane Lippman from the New York City Housing Authority Law Department on behalf of appellants Shola Olatoye and NYCHA. And I'd like to reserve 2 minutes of my time, please, for me. There is a disconnect.
Counsel, in order to be in compliance with the state and city and the federal anti-discrimination laws, what is NYCHA's protocol when someone with a disability requests that they have someone stay with them in the apartment?
NYCHA's obligation under the law is to provide an effective accommodation, so one that affords equal opportunity for a disabled tenant to use and enjoy her apartment.
And how do you make that determination? Again, what's the process that you do to respond to these requests?
Yes. So it's a multi-pronged answer. First of all, NYCHA has in place an exception to its occupancy standards. So as a reasonable accommodation, NYCHA provides temporary residency to a caregiver for a disabled tenant who requires 24-hour care. So this is an exception to NYCHA's occupancy standards. Ordinarily, temporary residency is limited to 1 year. However,
I think I'm not making myself clear. When someone presents the request, what is the NYCHA personnel supposed to do?
Okay.
Because you're telling me how you get to the eventual conclusion.
Yes.
That's not my question.
So
what are they supposed to do?
There is a public housing reasonable accommodation coordinator, and this is set forth in NYCHA's standard procedure for reasonable accommodations. So if there's some reasonable accommodations are evident, very clear. For example, a tenant may require grab bars in a bathroom. Where the nature of the accommodation is not clear, then the public housing reasonable accommodation coordinator will get involved. The request for accommodation will be forwarded to the coordinator, and the coordinator will evaluate the request and engage in the interactive process in accordance with the law.
So when someone says, I have a disability and I need someone to live in this apartment with me, does that go automatically to this reasonable accommodation coordinator?
No, it does not, because NYCHA already provides a reasonable accommodation in the form of providing temporary residency to a caregiver. So again, this is an exception to NYCHA's occupancy standards. Now,
okay, so I didn't realize that from your briefs. So NYCHA's position is that it need not ever enter one of these discussions, right? It does not have to do the interactive process because it has, as an administrative matter, already decided what in every case, regardless of the individual circumstances, would be a reasonable accommodation.
And no, I would disagree with that. I would say that's not correct. Okay. If the temporary residency of a caregiver is not an effective accommodation, and I can't envision why that would be, but if it were ineffective, then NYCHA would engage in the interactive process. The denial of permanent residency permission can be grieved. It's right on the form.
But how would you come to the conclusion, that threshold conclusion, that it's not, that your regular approach would not satisfy the anti-discrimination law?
Well, for example...
If you haven't done the interactive process.
Right. For example, in this case, the tenant submitted a permanent permission request. NYCHA also has a reasonable accommodation form that wasn't used in this case. So the tenant submitted a permanent permission request, which was denied. Now, on the permission request, it does say that you can grieve the denial, and I would refer the court to Matter of Poso, which is a case from the First Department, where in fact the tenant brought an Article 78 proceeding to challenge the denial of permanent residency permission. So,
counsel, on that front, I'm having a little trouble understanding how all of that argument fits into this proceeding, because it seems to me, if you're looking just at succession rights, which is what we're talking about here, you have to almost conclude that the only reasonable, either one of two things, I think, the only reasonable accommodation would have been to grant this type of status to this person in the disability proceeding, in the accommodation proceeding, or that to punish the agency for not having some kind of procedure, you're going to find that this tenant had succession rights. So I'm having some trouble and understanding how that whole analysis of what would have been a reasonable accommodation fits into this person's request to have these type of succession rights. The simple answer here is he doesn't have them, right? And if you had a problem with the other proceeding, you could have grieved that other proceeding.
That's right, Your Honor. That's absolutely right. And the failure to fully engage in the interactive process, and we do concede that NYCHA's interactive process was not well implemented in the case. However, the failure to fully engage in the interactive process is not a benefit wholly unrelated to the disability, such as succession rights for a caregiver.
Did NYCHA grant temporary status? Well, let me ask it differently, maybe, since I see you're hesitating a little bit. NYCHA didn't grant temporary status. Is it common that NYCHA simply does nothing and treats that as if, or is this unusual?
No, this is aberrational. Temporary residency permission should have been formalized in this case, and we can see that this was not a good example of NYCHA's interactive process. Normally, temporary residency would be formalized. Would be a meeting with management wherein it would be explained that permanent permission could not be granted because the addition of respondent caused overcrowding.
Where was the breakdown here?
I think
Building manager gets the request and denies the request for permanent, but there's no eviction proceeding started or anything like that. What should have happened next?
That's right, and there were no steps taken at all to evict Ms. Aponte. What should have happened is there was a meeting with the Resident Services Associate, Mr. Burson, in January 2011 to explain that respondent could not be added to the household due to overcrowding. What should have happened and what typically would happen is that there'd be a meeting with the manager, the tenant of record, the person who wishes to move in, and it would be explained that the addition of this person could not be permanent due to overcrowding, and that temporary permission could be offered, and it would be formalized. In this case, as the dissent found in the first department, there was de facto temporary permission.
And if the tenant has, as perhaps might have been the case here, obviously at some point, cognitive limitations, assume that NYCHA allows for the guardian or someone who is tasked with the responsibility of caring for this individual to engage in this conversation?
Absolutely, absolutely. Respondent could have assisted his mother, another friend or family member can assist, absolutely.
So, can I, if Judge is all right, how would they have done it right? How would they have followed your rules?
What should have happened and what typically would happen is that a meeting would be held with the development manager, with the tenant of record, and
No, assuming all the means, would they have applied for temporary residency first, and then could they have applied for permanent residency to establish succession rights? Is that allowable within the rules?
in this case, permanent permission could not be granted. Ever in this case because of overcrowding under NYCHA's occupancy standards. However, temporary permission should have been formalized.
So that begs the catch-22 question, succession rights then could never have been established.
But it's not a catch-22.
Okay, go ahead.
It's not a catch-22. So whether the...
Why isn't it? All right.
So whether the addition of a family member will result in overcrowding under NYCHA's occupancy standards depends. NYCHA's tenant selection and assignment plan allows for various combinations of family members in different size apartments. So,
but assuming those weren't the people that were available as caregivers, I think as a follow-up to Judge Fahey's question, what would the process have been to request permission to move to a larger apartment?
So,
I assume that was a possibility.
well, first of all, Ms. Ponte did not request a transfer to a large apartment.
I know. My question is, what would the process have been to make that request? Would it have been to grieve the refusal of permanent residency permission, or is there some other mechanism that would have been done?
So if the tenant has a medically documented need for more space, so that transfer would be appropriate, which Ms. Ponte did not in this case, but hypothetically, then during the interactive process with the manager, the issue of a transfer would definitely come up. Say the tenant needs an oxygen tank or medical equipment, and NYCHA's standard procedure on reasonable accommodations specifically states that a tenant may transfer to a larger apartment as a reasonable accommodation where there is a need for medical equipment. So yes, this would come up in the normal course of NYCHA's interactive process.
The need to have a permanent caretaker would not be one of those circumstances. Is that what you're saying?
The need to have a permanent caretaker would
Not be a circumstance which would permit someone to move to a larger apartment.
No, because NYCHA doesn't know whether other caretakers may be needed over time. I mean, it's not unusual to have different caretakers. A professional caretaker may be needed. So the need for a caretaker in and of itself does not necessitate a transfer.
No, isn't the point the nature of the disability and what the caretaker must do to ensure that the individual who needs the services is indeed provided the services to age out in their home? So
Yes.
It doesn't matter really if it's permanent. That's not really the point. The point is, what are they doing, and can they do that in a one-bedroom apartment?
I think that's right. Yes, we agree with that. I mean, the nature of the accommodation, so the accommodation is framed by the disability, and the appropriate accommodation is determined by the medical documentation and the nature of the disability.
Thank you, Ms. Lippman. Counsel?
Good morning. May it please the court. My name is Leah Goodridge from Mobilization for Justice on behalf of Jonas Aponte.
Counsel, I'd like to follow up on what I think Judge Garcia was getting at a little bit, which is I'm having a hard time understanding why we're even talking about the accommodation of this tenant's disability, because it seems to me that the denial of permanent residency was never grieved. It was never raised in front of NYCHA or and can't be raised for the first time in an Article 78 proceeding. And why are we even talking about whether there was reasonable accommodation in this position that we're in?
We're discussing that because the legal standard here is whether Mr. Aponte was denied succession rights on the basis that NYCHA failed to provide reasonable accommodation. Here, the only reason that Mr. Aponte was denied succession rights is because NYCHA did not provide written permanent permission for Mr. Aponte to join his mother's household when she originally applied for that.
Well, suppose NYCHA had provided a two-bedroom apartment, but on a temporary basis for Mr. Aponte as a resident. Would that have been a reasonable accommodation?
Well, I think here, succession rights is permitted. So, for example, if Ms. Aponte had a two-bedroom apartment and she had a son who just wanted to move in to have a place to stay, not necessarily to be a caregiver, then she would have been granted permanent permission, so the overcrowding wouldn't have been an issue. But here we have a case where Mr. Aponte moved in to care for his disabled mother who
I'm
was
asking
dying.
something a little different, I think, which is she has a one-bedroom apartment. She has a medical need because she has dementia. And what NYCHA didn't do this, but suppose what NYCHA had done is said, look, we will offer to move you in the same building to a two-bedroom apartment that you can have, but on the condition, and your son can live there, but only as a temporary resident, not a permanent resident. Would that have satisfied anti-discrimination law?
In this particular case, that may have satisfied anti-discrimination law, but what the appellate division found is that we don't know what NYCHA would have done. NYCHA's main argument relies on the premise of what it would have done or what it could have done, but we know what NYCHA actually did, and the appellate division looked at that. There were several opportunities for NYCHA to come to the right conclusion.
But as a policy matter, just to follow up on Judge Wilson's question, it's a distinction between the right to accommodation and the right to succession, I think, that we have to look at. And I have a difficult time drawing that distinction, because if you say they have accommodated them, if it was done correctly, he could have been accommodated, theoretically, then succession just isn't a possibility at all. And the right to accommodation doesn't automatically lead to a right to succession. And wouldn't your argument lead us to that? wouldn't your argument, the end result be, whenever we accommodate someone in a particular setting, that they automatically gain succession rights?
So there are several different ways that NYCHA could have accommodated Ms. Aponte. Here, they could have granted her permanent permission status. And I want to just make a quick point that reasonable accommodation is an exception to a rule. You cannot simply reiterate a rule and claim that that is reasonable accommodation. So that would have been allowing Mr. Aponte to move in and have permanent status.
But why
That
would
would have been one
Why would that
accommodation.
be a greater accommodation than what they in fact did, as regards Ms. Aponte's disability?
I'm sorry, I didn't hear the question.
Why would giving Mr. Aponte succession rights, permitting him to move in as a permanent resident, have given Ms. Aponte, his mother, a greater accommodation to her disability?
Well, I think NYCHA makes that argument in its brief, and it mischaracterizes the legal standard. The legal standard here is that it's a two-question. Did NYCHA violate the laws by failing to provide a reasonable accommodation? And as a result of that, was Mr. Aponte harmed? So
But
here,
back to my point, there's no record here to determine whether a reasonable accommodation was made because nothing was ever raised in that regard. The only thing, nothing was done. Nothing was done at all.
And that was NYCHA's burden to bear. So, for example, there are several ways where Ms. Aponte requested accommodation. She submitted, NYCHA received not one but two requests. On one form it said, I am sick, dementia, need help. There are no magic words that a tenant needs to use to say that I need a reasonable accommodation.
And once they didn't get what they wanted, don't they have to let them know that this isn't good enough? Or we want a bigger apartment, or we want, I mean, they asked for permanent permission, but then when it was not granted, they didn't do anything. So
the legal standard here is not on the tenant. The legal standard is after the tenant requests a reasonable accommodation and a landlord refuses it, it is on the landlord's duty, the
I think
landlord's
Judge
burden.
Stein's point on that is that standard is applied in the accommodation proceeding, not in a subsequent collateral proceeding on whether or not this person has succession rights. All those standards and a review of what was and wasn't done should have been done in a objection or grievance of that proceeding itself, where there's a full record. And it seems like now your argument, again, has to be one of two things, that the only reasonable accommodation, we would have to conclude, would have been, and this goes to Judge Wilson's point, that permanent succession rights, permanent residency should have been granted when she actually got the accommodation, in fact, that she was looking for. This person stayed, the son stayed, or because of some failure in the process, we're going to send some type of deterrent message to the agency that you have to do this the right way. And that seems, both of those things seem difficult to me to accomplish in this proceeding.
There are 2 points to answer that question. The first is that there's no, the point that there's no record really is based on NYCHA's failure to engage in the interactive process. Ms. Aponte, it's undisputed that they received information that they had a 90-year-old woman with a mental disability who reached out for help.
Wouldn't
That's
that
the
all
first
that
point.
record have been then developed in a direct grievance of that proceeding, which we cannot be done here?
It can be done because Mr. Aponte brought this proceeding under the premise of associational discrimination. What that means in sum is that a tenant may be able to bring a proceeding, any person under the Fair Housing Act and under a reasonable accommodation may be aggrieved. That person does not have to be a person with a disability. So the legal standard that the appellate division looked at is whether a person was harmed because a landlord failed to provide reasonable accommodation or discriminated in another facet. So, for example, there's case law where children in a hospital provided sign language to their parents. The hospital, that case is Loeffler v. Staten Island. The hospital did not provide the reasonable accommodation. The parents received it anyway, but the children were able to bring that case under associational discrimination. So the legal standard is whether Mr. Aponte was harmed or not. And clearly we're here today because Mr. Aponte is facing eviction. That is a harm.
No, but I think that the problem that I see with your argument is that the harm is not the one you're pointing to, the succession rights. The harm would have been if they tried to evict him. That's the harm, because she needs the assistance, he's willing and wants to provide it, and NYCHA is standing between her request for assistance, his willingness to do so, and then you can have sort of that process of figuring out how to respond to her needs. But that strikes me as where he might have a claim to the harm, but not that, oh, I should have been put with my mother in the position to eventually have succeeded to a lease to that apartment, or, as Judge Wilson suggested before, if they had been moved to a larger apartment, to that other apartment. And I think that's where I'm having difficulty, under the framework of the anti-discrimination law, to follow your analysis.
Okay. The anti-discrimination laws here have been, have been over 4 decades. And what's clear here, and the standard that NYCHA had to meet, was whether Mr. Aponte was harmed here. The only reason that Mr. Aponte is being evicted is because he did not receive succession rights. He didn't receive succession rights because NYCHA did not grant Ms. Aponte's requested reasonable accommodation for written permanent authorization. What NYCHA argues
That's where
today—
I think the argument sort of falls there, because that again presumes that the only reasonable accommodation rights would have resulted in permanent residency for Mr.
Well, here in this particular case, the main distinction between temporary and permanent permission, as NYCHA states, is that a tenant would have to renew the temporary permission every year. So permanent permission was suitable. And in this case, Ms. Aponte clearly showed that she had a mental disability. She could not remember the year, the season. And for her to renew every year, it would have been more suitable for her to have permanent permission. So that
the standard
argument—
more suitable? Is that the standard?
Here in this particular case, NYCHA had to show why it was an undue burden to grant permanent permission. It hasn't shown that. And in this case, the record is clear that Ms. Aponte suffered from a mental disability, and she needed someone, and she was also elderly and had a physical disability.
And the
She needed someone to
NYCHA
move in.
rules, as I've read them at least, in the case of a caretaker, allow for the automatic renewal by the building manager every year and don't require reapplication. Is that right?
I'm sorry, what's—
The NYCHA rules, or the handbook that I saw, in the case of somebody who is allowed temporary residence as a caretaker, do not require reapplication every year. The building manager can simply grant that.
NYCHA cites to a rule about caregivers, about home health attendants, but those are for paid home health.
Where does it
or-
say paid in that?
Those are for home care. The specific title, I believe, says home care attendants.
And do you have
This
is there any NYCHA precedent that would, or anything you know of that would indicate that that person cannot be an unpaid family member?
Well, in this particular case, Mr. Aponte, Ms. Aponte applied for permanent permission, and the legal standard here is why the permanent permission should not have been granted on the basis of undue burden. And NYCHA continually has reiterated that it has a policy, but the legal standard to bear is why it should not have made an exception to that policy. The appellate division held this decision right, and in addition, NYCHA's policy here discourages aging in place. For example, a person who wants to move in like Mr. Aponte and care for his mother who raised him, who could not at the end of her life remember even who he was, no one is going to move in and do that if they know that they're going to face eviction. So it discourages aging in place, and is arbitrary and capricious for that reason, as cited in our amicus brief by the AARP.
Thank you, counsel.
Thank you.
Ms. Lippman?
Thank you. I would just like to make a few points. First of all, there's been no argument here that respondents' temporary residence in Ms. Aponte's apartment was ineffective. Also like to add that temporary residents, such as respondent, never pay rent. Okay, their income is not included. That is part of the reasonable accommodation. Also, as Judge Wilson pointed out, renewal of temporary residency permission for a caregiver whoever the caregiver may be, a professional, a family member, friend, can be automatic. Management may automatically renew it. NYCHA does not need to assert the undue burden defense here. Ms. Aponte was reasonably accommodated. Also, I
Can I
just...
ask you,
Yes.
the hypothetical that Judge Wilson posed to your adversary, would that violate the federal HUD regulations?
The hypothetical...
So moving them to a larger apartment, but only giving the son temporary?
No, it wouldn't violate it.
You could have moved them
Well,
instead of leaving them in the one-bedroom in an overcrowded situation, with the same outcome that he doesn't have succession rights. Is that true?
well, in this case, the medical documentation did not indicate a need for more space. Oh, hypothetically. Oh, okay.
Let's assume that it would. My
Yes.
question was, could you do that?
Yes,
And grant temporary?
Yes.
I thought again,
They could
I'm
ask for
misreading your
permanent.
briefs, because I thought your argument was that if he was in a non-overcrowded situation, that he would have had rights. He could have made the argument for succession.
he could request it, yes. If one wishes, if a family member, one of the delineated categories of family members, wishes to move into the apartment, the addition to the household will not result in overcrowding.
But can you grant the move to a larger apartment if he's willing to waive his rights to that request?
Sure.
That's allowed by the federal regs.
Yes, and I would add that professional caregivers are never entitled to permanent permission. That is undisputed in this case. If Your Honor is referring to a family member, a family member may request permanent permission. They don't have to request permanent permission, but they may. Yes.
What does NYCHA do to address this last concern that your adversary raised, which was raised by the briefing, the amici?
The last
About discouraging aging in your home and discouraging or undermining the opportunity for a family member to stay. Because unless, certainly in New York City, to request the family member, I mean, there's a sacrifice anyway, to give up perhaps their permanent home to come to NYCHA to take care of their aging, dying relative and then not have a permanent home is quite the burden.
Yes, Your Honor, and NYCHA fully supports and promotes aging in place by allowing caregivers to live with a disabled tenant with automatic renewal of the residency and exclusion of the caregiver's income from calculation of the rent. So the caregiver may live there for whatever period of time his or her services are needed, rent-free. There is no need to give up another residence.
No, I get that. Let me ask the last question, because you have the red light. I know we've gone over. If Ms. Aponte had medical documentation that established that what she needed was not someone who was not known to her, even though she has dementia, I get that, but that she needed this relative to actually provide the care, and the relative establishes through evidence that unless they're given a permanent, unless they're given a lease, they cannot leave their home. They can't afford it. They can't risk it. Would those be factors you would take into consideration? Or they're irrelevant to this because you've already made a decision that you can never overcrowd?
Reasonable accommodations, by definition, are decided on a case-by-case basis. I cannot envision a circumstance where NYCHA would need to grant permanent permission to a caregiver. NYCHA does not need to accommodate the comfort of a caregiver. However, should such a situation arise, the option is not foreclosed.
Thank you, counsel.
Thank you.